Ready? Okay. This is Circuit Court File 1812024FH, People versus Brett Anthony Striegel. And the record should reflect we're conducting this proceeding by Polycom. Mr. Striegel's lawyer is Mr. Gary Springstead. He's currently in his, looks like he's in his office. Assistant Prosecuting Attorney, Mr. Holmes, is in the courtroom. And we're here. The defendant was convicted in a trial by jury of one count of breaking and entering with intent to commit a felony in violation of MCL 750.110 and two, taking possession and driving or taking away of a motor vehicle in violation of MCL 750.413. The defendant, through his attorney, has filed a motion for a new trial pursuant to MCR 6.431A, Parents A, Parents 2, and MCR 7.208, alleging the prosecution withheld exculpatory evidence from the defendant. The defendant further alleges that this withheld evidence constitutes newly discovered evidence, which further warrants a new trial. Mr. Springstead, you filed a brief in the matter, and court read it. And Mr. Holmes, you filed a responsive brief. Court read that as well. And Mr. Springstead, and I indicated that your client didn't need to appear, so I don't think he's in your office, is he?
No, but he is in Zoom. He is in the Zoom meeting, Your Honor.
Oh, I'm sorry. What would you? Okay, so he's watching the proceeding.
I believe so. Yes.
Okay, because I don't see him at all on our screen, but
it may just be sound.
Okay, he may just have the sound. Okay. And I'm looking at People versus Kress, which is 468-678, indicates for a new trial to be granted on the basis of newly discovered evidence, a defendant must show, one, the evidence itself, not merely its materiality, was newly discovered. Two, the newly discovered evidence was not cumulative. Three, the party could not, using reasonable diligence, have discovered and produced the evidence at trial. And four, the new evidence makes a different result probable on retrial. Mr. Springstead, was there anything else in addition to your motion you wanted to address with the court on this matter?
No, nothing additional from our briefs, Your Honor.
Okay. Mr. Holmes, was there anything else in addition to your responsive brief that you wanted to bring up with the court?
Nothing additional.
Okay, thank you. Well, the court would indicate that I appreciate both briefs were well written and provided the court with insight as to the legal arguments here, and the court found that both sides presented the facts at trial correctly, as I recall, because I presided over the matter. After reviewing the briefs, the court is denying defendant's motion for a new trial as to both theories. Now, the first theory the defense has raised, prosecution suppressed material evidence in violation of Brady versus Maryland that was relevant, admissible, and necessary for defendant's defense. Now, the three components of a Brady violation: one, the prosecution suppressed evidence; two, that it is favorable to the defendant; and three, that it is material. Now, suppressed evidence is material if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. That's U.S. v. Bagley, 473 U.S. 667. The test for whether the material evidence should have been disclosed is whether it contains information that probably would have changed the outcome of the trial. And that's People versus Stanaway, 446 Mich. 643. Now, it is this court's finding, after reviewing the briefs and reviewing the evidence, as I recall, because as I indicated, I presided over the case, that the evidence involving Zachary Farmer, which was indicated by which was provided in the briefs, The court finds that information was not material, as defined by case law. The suppressed evidence would not have changed the outcome of this case. The court agrees with the prosecution that the evidence in Farmer is significantly and substantially different. The court would indicate that the cases in Farmer, well, the case at hand, People versus Striegel, alleged in December of 2016 that a vehicle was stolen and burned up, and a break-in and entering occurred. Now, the court feels that based on what the court has been told about the facts in Farmer, and the court would indicate the Farmer cases took place about 15 to 20 months later than the Striegel case. Also, the modus operandi was somewhat different. The vehicles in Farmer, the facts in Farmer, the vehicles were all found in Newaygo County. They were not disposed of near a family or a friend's location. But really one of the major factors this court considered was the major components of the vehicle were not missing in the Farmer case as it was in the Striegel case. And the court agrees, it appears that Craigslist was not utilized in the Farmer cases to locate the vehicle or sell the vehicle or look for information on vehicles. Based on what was presented to the court in the briefs, this court finds that the facts in the Farmer cases apparently dealt with like 2 or 3 or 4 cases where vehicles were stolen and then set afire. In those cases, it appears based on those factors, the court agrees with the prosecutor, it neither inculpates or exculpates the defendant. Now, as to theory 2, the Crest, here's the argument, is the Crest test further supports a new trial because the suppressed evidence constitutes newly discovered evidence. The court denies the defense motion relative to this theory. In order to justify a new trial based on newly discovered evidence, a defendant must show, as I indicated previously, these are the factors outlined in People versus Crest, that the evidence itself not merely its materiality was. Hold on, I'm going to go over that again. The factors in Crest again is the evidence itself, not merely its materiality, was newly discovered. The newly discovered evidence was not cumulative. The party could not, using reasonable diligence, have discovered and produced the evidence at trial. And 4, the new evidence makes a different result probable on retrial. The defendant's argument as to the 4th prong has no basis, this court believes. As previously stated, the Farmer's evidence neither exculpates or inculpates the defendant. The prosecutor's argument that looking at all the evidence produced at trial, nothing by way of the Farmer's criminal activity changes any testimony or exhibits that were introduced at trial. So based on all those factors, the court's denying the motion for a new trial. Mr. Springstead, I'll prepare an order and that'll be sent out to the parties. I'll try to prepare it. I can do it today, or the clerk's not going to, is here till 11. I think we can still get it done, and I'll send it out. Hopefully you'll get it about Monday. I know that's something that the parties want, so I'll get it out as quick as I can. All right?
Thank you, Your Honor.
Thank you. All right, thank you. Thank you, Mr. Holmes.
Thank you, sir.
Yes, sir. Ms. Robinson, are you ready to go on your matter?
I am, Your Honor.
Okay. Your files get kind of thick there, Bob. can't see Ms. Muir yet. Oh, there she is. Ms.
Good
Muir.
morning, Your Honor.
Good morning. Ms. Muir, I'm actually sitting in circuit court. We're having problems in district court, so that's why you're probably getting a little different view this time.
Yeah, different side.
Yeah. Do you need, well, first of all, I want to do a couple of things. This is circuit court file number 19-012218FH, People versus Noel Colette Patton. The record should reflect that Ms. Patton is is at the jail, and we're conducting this by Zoom or Polycom. Ms. Muir, her lawyer, is in her office in Grand Rapids, and Assistant Prosecuting Attorney Ms. Robinson is in the courtroom. And this case has been reassigned to me pursuant to a local administrative order. The defendant, through her attorney, Ms. Muir, has filed a motion to modify her sentence in light of COVID-19 epidemic, current lack of services available at the jail, and her elevated risk factors that she has. And I hope I indicated that all accurately, Ms. Muir. And Ms. Muir, do you need a few minutes to talk to your client?
I might just check her sound and just make sure she's ready to go with her statement, Your Honor. Just if I could have about 30 seconds.
Yep. So we're gonna put can you mute it and then give me the thumbs up when you're ready to go?
Okay. Thank you, Your Honor.
Okay.
Hey, Noelle.
Hi.
Hi. All right. I can hear you. Okay.
Okay.
Are you do you have any questions for me before we start?
No, I think I'm ready.
Okay. All right. Don't be nervous. I can hear you just fine, and I see you have your statement written. So when I'll speak first, and then the judge will ask if you have anything to say, and then you just take your time, like speak at sort of a higher volume than you might normally, because the audio's not great.
Okay. Is this good?
Yeah, that's great.
All right, good.
Don't feel rushed. Can you hear me okay? Last time I had some issues with my sound.
Yeah,
Okay.
I can hear it just fine.
Okay, great. I think we're good to start then if you are.
Okay, thank you.
Okay, and then I'm going to call Jeff right after the hearing as well, so I'll let him know how it goes.
Thank you.
Okay, all right. We can't hear you, Your Honor. I think you're still muted.
Okay.
There we go.
Could you? Okay. You had an opportunity to talk to your client?
Yes, Your Honor, I did.
Okay. Ms. Patton,
Yes, sir.
Can you see and hear me?
I can hear you very well and see you clearly.
Okay. If at any time you can't see or hear your lawyer or me or the prosecutor, would you let me know, and then we'll try to fix the problem?
Yes, Your Honor.
Okay. Now, Ms. Patton, you do have a right to be in the courtroom for this proceeding, and if you wish to, I can adjourn it and reschedule it and have you here with your lawyer and the prosecutor. But your lawyer has indicated she just prefer to do it by technology, the Polycom. Do you have any objections to that?
No, sorry. I think it's the safest way.
Okay, and Ms. Muir, you don't have any objections?
No, Your Honor, this is fine. Thank you.
Okay, and the court, I want to make sure, I did review your brief, Ms. Muir, in the matter. The court also read, I just got it yesterday, a responsive brief from the prosecutor. Did you get a copy of that? So I want to make sure you had a chance to look at that. Okay. Ms. Muir, was there anything else in addition to your brief you wanted to address with the court?
Not in addition, Your Honor. I just, upon receiving the prosecution's brief, I echo the sentiment certainly that Ms. Patton's behavior has been dangerous to herself and to the community, and I share the concern that that will continue. What worries me the most about her current situation is that she is not getting any alcohol treatment programming during the COVID-19 lockdown, which makes perfect sense for all of the health and safety reasons not to move people about in the jail. But in light of the governor's executive order and the court's authority to modify her probationary sentence, and upon talking with Ms. Patton extensively about the source of her criminal history, it really is all substance abuse, drug seeking, drug-induced and alcohol-induced behavior. And I know she has completed a previous program in 2015, 2016, when she was incarcerated at Women's Huron Valley facility. And I just wanted to point out for the court that that was successful. She completed that program successfully, and it was specifically for drugs, which was her problem at the time. She had a lengthy history of opiate addiction that stemmed from a prescription that she received in the emergency room. And that program was successful. She completed it. She has not used drugs since then. However, a month before she was released from prison, her fiance, with whom she's been since 2008, his teenage son committed suicide a month before her release, and that triggered a wave of grief and trauma that was not addressed for her and also not addressed for her fiance, with whom she still lives. And in the absence of being able to turn to drugs like she had in the past, she replaced that with alcohol. So she has not had the treatment for the underlying grief and trauma related to the child's death, and also has not had any alcohol-specific treatment. So we certainly do not oppose the government's request for the SCRAM unit, and as regular drug testing and alcohol testing, in fact, as possible, to protect her and to protect the community.
Okay. I have a couple questions for you, Ms. Muir.
Yes, Your Honor.
Was your client on parole at the time of this current case?
I do not believe so, but may I ask Ms. Patton?
Sure you can.
No, sir, my parole ended in early 2018, I believe it was.
Okay, all right. Ms. Muir, does your client, I don't know if she has the wherewithal for an inpatient program, and I see that you weren't necessarily requesting that, but does your client have a program in mind that would be favorable or approved by the probation department?
She is hoping for an outpatient program, Your Honor. Because it's alcohol specific, I imagine that there are more options through private counseling even than there would be for drug specific. I think KPEP has outpatient treatment going on right now that could be a possibility. And last time I checked with probation, although not in this particular case, the KPEP was accepting people within about a week turnaround or less.
Okay.
That was a couple of weeks ago that I checked on that, Your Honor.
Very well, thank you. I had another question for you. I'm trying to think of what it was. Anything else, Ms. Muir, at least at this point?
Not for me, Your Honor. I know Ms. Patton has a statement that she'd like to give when
okay.
the court is ready.
Well, I'll give her a chance to say that. Ms. Patton? Was there
Yes,
anything? Let me do this, Ms. Patton. Would you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide in this matter is true to the best of your knowledge, information, beliefs, help you God?
Yes, Your Honor, it is.
Okay, why don't you go ahead and tell me what you think I need to hear?
Well, in the answer to the question that you asked, Ms. Muir, I did begin with Arbor Circle here inside of the jail, and that was furloughed after 3 meetings. And I do plan to return to that immediately upon my release. I've also gotten some literature about a drug called Vivitrol from them, which they are able to administer, and I'll certainly be speaking more in depth with that healthcare provider about that upon, when I'm released. I attended an inside program here called Addictions, which is a faith-based program that they provided us with, which I enjoyed very much, and will be seeking that on the outside as well, as along with anything that my probation officer or you yourself require of me. After I was arrested, I was asked by a friend to join a grief group at the First Reformed Church in Fremont, and I attended that for several months. And I found that very helpful because not only did it help me dealing with my feelings, but I also was exposed to a lot of people who had lost loved ones for the same bad choice that I was making for myself. And that was a real eye opener for me. Touched me deeply. Jeffrey has also agreed to attend those meetings with me when I return, which he's never done before. He's never really agreed to taking any kind of counseling for the grief. And that is I'm optimistic about that because dealing with his grief has been harder than dealing with my own at some times because it was his son and he lived with us solely in our household. So it was hard. It's been a struggle for us both. He certainly deals with it in much better ways than I do. But I do look forward to getting him involved in the the healing part because it's been almost a little over 4 years now and it's time for us to heal together or we're just not gonna, neither one of us are gonna make it through this. I'm eager to start my community service. I know that there's a lot of things that are going on in our community where they could use people who could help. In here, the fear is some days quite honestly very, very overwhelming. Our only outlet is the news and the media, and it gets a little scary at times. So I'm eager to do whatever I can to help, and certainly within the boundaries of keeping my family safe. I do.
Well, it's a little scary out here.
I understand. I do.
Yeah.
It's.
But Ms. Muir, I didn't mean to cut you off. We'll get back to you again in a minute, Ms. Pat. Ms. Muir, I remember what I was going to ask you.
Yes, sir.
Your brief indicated, well, I'll indicate for the record, your client was convicted of operating under the influence or intoxicated third offense. The guidelines were 7 to 34 months. I believe she was sentenced to 9 months
Yes,
in
Your
jail.
Honor.
And is it your understanding, it looks like she has about 4 months in already?
Yes, Your Honor. She's now in her 5th month.
Okay, I just wanted to put that on the record. Hey, I'm sorry, I didn't mean to cut you off, Ms. Patton. Anything else you want to say?
No, sir. I just appreciate your time in considering this, and I'm just eager to do whatever I have to do to help my family,
Okay.
community, myself, anything I can do, whatever it takes.
Now, I want to give the prosecutor an opportunity if there's anything that she wants to say or anything in addition to her brief. Ms. Robinson?
Thank you, Your Honor. I want to rely heavily on the information that we put in our brief regarding this defendant's past behavior and the fact that it hasn't changed. And I understand that there may have been some grief type situations that happened, but I'd like to point out that even just in terms of drunk driving, she had another one in March of 2017. That wasn't enough to change her behavior. We ended up back here. The indication that she would like to get involved with these programs, they're not happening in the jail right now because of COVID. Well, it's my understanding that all of these programs, even on the outside, everything has been changed because of COVID, and I'm not convinced, and our office is not convinced that there are going to be ample opportunities for this defendant to be made safe for the public. We absolutely understand the concerns that this pandemic has created for the safety of prisoners in the jail, but I think that even in light of the executive order and the discretion that the court clearly has, the concern of protecting the public outweighs the concern here in that this behavior is going to continue. The idea that grief is and stress, anxiety are some of the things that have been causing this, those things are happening now. We're in a very stressful time. I don't believe that those things are going to be properly addressed. I believe that this defendant will continue to engage in behaviors that are dangerous, not only to herself, but to members of the public. This is the 3rd time she has done this. Specifically, the 2nd drunk driving in the last few years after she has completed some of these programs. She has had ample opportunities, ample services given to her over her life to address these things. It hasn't happened yet. Now, in the midst of a global pandemic, is not the time for us to believe that she's going to be able to find the resources on her own that she needs on the outside. I believe it's absolutely imperative that this defendant remain in jail. I think that is the only way to ensure the safety of the public. The only way to keep this defendant from reoffending at this point is to keep her in jail. as has already been admitted, she hasn't been receiving any sort of treatment in the jail at this time. So there has been nothing to address these behaviors, and releasing her would be reckless. In addition, we just heard the defendant say, that I believe it's her husband is going to, engage in some of these things, and she's very optimistic about that because dealing with his grief has been hard. Well, we can't ensure that he's going to do anything different. The idea that somebody else's grief and her stress levels and her grief levels and her coping is reliant on somebody else changing their behavior creates a particular danger in my mind, because we can't rely on that and we have no authority to ensure that any of those things happen. So I know that we did ask that in the alternative, if the court decides to grant this motion, that scram unit and regular drug testing would absolutely be necessary. Those would be the absolute minimums that we believe could even be justifiable. But in reality, we believe that the only way to protect the public is for this defendant to remain incarcerated and to serve her time. She's had the opportunities. The risk to her does not outweigh the risk that she poses to the public if she is released at this time. So we would ask that the court deny this motion.
Ms. Robinson, your brief also indicated that the reason that the conviction, I should say, was premised on an accident too. Is that right?
Yes, Your Honor. She, it's my understanding, and I apologize, I didn't handle this case before, but we're on a rotating basis. But it's my understanding that she ran a red light and essentially T-boned another vehicle at a .21. This is someone who, that was November of 2019. Her previous drunk driving had been March of 2017. She had ample time to address a lot of these things. This isn't that something new came up. She is just continuing to engage in the same behavior. She had already put herself and whoever was in this vehicle in direct risk of extreme physical harm. And at this point, a third drunk or intoxicated driving that results in an accident, we just do not believe that there's any other way to maintain the safety of the public at this point, but for her to remain incarcerated and to serve the remainder of her sentence.
Ms. Muir, did you want to respond or anything else in addition to what you've already indicated?
Just, Your Honor, a point of clarification. The accident with the drunk driving incident actually was in July of 2019, and her guilty plea date was in November of 2019, and she remained on bond successfully until her sentencing in January.
Very well. All right. Ms. Muir, I'm going to grant your motion. The court finds several things. One, the defendant has served 4 months already. Two, that she is currently really not receiving the treatment in the jail. In the courts, it's understandable. It's very hectic at the jail. The jail's under a lot of pressure, and the people that work there are under a lot of pressure. And the court does find that the defendant, her situation does fall within the executive order number 2020-62 and MCL 771.2 parents 5. The court orders modification of the defendant's sentence to time served. The defendant can be immediately released today. We'll prepare an order today so she can be released. The court agrees with the prosecutor. I'm going to order that she be placed on a scram unit. I think that's absolutely imperative. And I understand when you're dealing with these kinds of situations, people can mean what they say, but when you get an addiction type situation, it sometimes the addiction can be so powerful it goes beyond what they feel and say. And so the court is going to order that she enter an outpatient substance abuse program as approved by probation parole. And that the defendant is to comply with all conditions of probation. And Ms. Patton, when you get out today, I don't know if probation parole is available today or not, but I want you to contact them at least by Monday, next Monday, and they'll talk to you and they'll set up an outpatient program for you and set up your scram unit.
I will contact them immediately.
Okay, if you do today, it'd be great. So the court will enter an order and direct the circuit court to file an amended sentence order consistent with the court's ruling. Okay, so you don't need to file anything else, Ms. Muir. I'm going to do it today.
Okay, thank you, Your Honor.
Okay, thank you, thank you.
Your Honor,
Yeah.
if I may quickly as a point of clarification so that we can notify the victim of this case, some of these specifics, is the court aware if those outpatient programs are continuing right now? Or is there a time limit by which this defendant is going to be required to find
Well, she's
something?
to successfully completed.
Well, I just mean.
Because I don't know what program it's going to be, but I think the previous case we just had a couple weeks ago was the KPEP program.
Okay, and those are still currently running?
Yes, they're still working. They're still in effect.
Okay.
Yeah.
And is there any limit on when she needs to start that by, or just?
Well, she's going to set it up with probation. She's going to call them today.
So they'll be in charge of setting when
Yes.
she begins that? Thank you, Your Honor.
Okay, no, that's fine. Anything else, Ms. Patton?
No, thank you, Your Honor. You've been very
Okay.
kind, and I will do my best.
All right,
I will do it.
and I'll prepare the order today, and we'll get it out today. And we'll get it over to the jail today, so she can get out.
Thank you so much.
Okay, thank you.
Thank you, Your
We're
Honor.
adjourned. Yep, thank you.